Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This is exclusively for the CPC students. We are going to discuss Order 11. That is, the heading would be Discovery and Inspection. How the matters can be discovered? Maybe through inspection. This is otherwise called as interrogatories. You are all well aware the word interrogation. What for interrogation is used? Interrogation is a way of questioning or a way of inquiring for getting the answers. Here the interrogatories also, they are a set of, a bundle of questions. Bundle of questions put to the other party to ascertain the correct or to clear any doubt. For clearing the doubt, normally right from Order 6, 7, 8 we have been discussing. Please remember, whenever you file a plaint or whenever you file a suit under Section 26 CPC Order 7, you have to give the defendant a copy. What for? To make his defense. Written statement, another copy to make the defense for the plaintiff. To give a set off, to give a to file a counterclaim, all these things you know. Even then, people may have a doubt. So to clear the doubt, interrogatories can be given. So please remember, interrogatories are otherwise known as the request for information. Not the questionnaire, a request for information. They are a formal set of written questions propounded by one litigant and which is required to be answered by the adversary or the opposite party in order to clarify the matter of fact. So this is, you can define it like this. So what is the use? It will help determine in his in advance what facts will be presented at the time of trial in the particular case. So Rule 1, Order 11, Rule 1. So it gives a proviso that you can discover the facts by interrogatories. Discovery by interrogatories. Rule number 2, particular interrogatories to be submitted. In this connection, please remember, you have to submit only one set of interrogatories, that too in form number 2, that too in the shape of an affidavit. You cannot go on giving the interrogatories once again. No, only one set of interrogatories. And according to Rule 6, suppose if the interrogatories appear to be vexatious, appears to be scandalous, or appears to be irrelevant, definitely you can file the reply. If the court agrees, you need not give any reply to the interrogatories. Sometimes the reply may be heavy, may be in volumes. Therefore, please remember, as per Rule 15, you can go and inspect the documents referred to in the affidavit. And friends, remember, Rule 21, premature discovery. Before submitting your written explanation, you can call for the records also. You can ask for the records and then you can put the interrogatories. Unless you study the matter, you may not be able to put questions. Yes, for that is also allowed. But please remember, when once the time is given as per Rule 21, so non-compliance with regard to the so-called discovery, that means you will not be allowed to put the interrogatories once again. So this is an important issue. Now what are the uses of the interrogatories? The uses are, number 1, to gain information from the other party. Whenever you get a doubt, yes, you can get the information from the other party. The second, the pleadings. They are intended to let the other party know what each side intends to prove at the time of trial. So that clarity you will get. But please remember, in most of the cases, the interrogatories are put to get additional information only. Right? No doubt. It is to fully understand the other party's legal and factual claim. This is also correct. Now, to cite an example, I will give you the ME Act case. For example, please remember, In MEOP, you file the MEOP under section 166 of the ME Act. So here the plaintiff alleges or says that the driver was negligent. Driver drove the vehicle in a rash manner and caused the accident. This is the allegation. To prove this, please remember, so law requires that P should have a duty of breach of care. P has breached the so-called duty of care. The result is the deceased received injuries. These things have to be proved. They have to be noted in the so-called pleadings. But if they are not given, then you can give the interrogatory like this. Interrogatory can be given seeking information as to how the accident occurred. What was the speed of the vehicle as per the MA report? Were the brakes applied incessantly, or whether there is any that mark? All these things you can ask. And also please remember, speed of whether the driver was speeding, what is the condition of the road, whether the road is curved or straight, all these things you can put, and this will give the information whether the driver was rash, whether the driver was negligent in driving the vehicle. So please remember this. So you can ask the question also, whether he paid proper attention towards the other vehicle. Suppose if it is a double road or single road, he has to take his vehicle to the left side, whether it was done or not. All these things he can put. So this is the use of the so-called interrogatories. Now I will tell you a case law also. This is Sri Ghanshyam Das Tekriwal, not Kejriwal. Ghanshyam Das Tekriwal versus Srimati Jayanti Tiwari and others. So please remember, in this connection, the Supreme Court stated, a party cannot file interrogatories to fish out the flaws in the opponent case. Your point is only to get clarity, not to fish out the lacuna or the flaws in the opponent's case. Likewise, in another case also, the trial court rejected application under Order 11, Rule 1 CPC. Endukani, just to administer the interrogatories, please remember, you cannot put any question. So the question should be, please remember, the reply may be absolute, the reply may be unqualified also. Sometimes you may not be satisfied, but please remember, only once you have to. And sometimes the documents also can be inspected before filing the defense also. This is stated in State of AP, that is actually District Collector Chittoor versus Kotta Cheruvu Plantations and Industries Limited, 1995. This Kotta Cheruvu Plantations and Industries, they got long history. How they got the property, so from Mathams they have got it. So these things, unless you go through the registered documents, is very difficult. So definitely you can go through the documents also. So please remember, that's all regarding the interrogatories. It's an important chapter. You may get question also. So get prepared and write the notes well. Thank you.